request sir to present a memento and shawl to Dr. Santosh Chawla ma'am for all her contribution to the development of Justice T.P.S. Chawla Library. Dr. Santosh Chawla has donated corpus fund of ₹1 crore for the augmentation of library, and the library is named Justice T.P.S. Chawla after her late husband, former Chief Justice of Delhi High Court. Corpus fund of ₹10 lakh for establishment of scholarship and gold medal in the name of her late husband, Honorable Justice T.P.S. Chawla. Corpus fund of ₹15 lakh for providing financial assistance to deserving students in the name of her late husband, Honorable Justice T.P.S. Chawla. Thank you, ma'am. Thank you, ma'am. We are so thankful to you for all your support and interest for the development of the library. I request Professor Ranbir Singh sir to present a memento to Mr. Vinay Ahuja. Mr. Akash, Dr. Singh and Madam Seema for all her support. Now I request our respected Vice Chancellor Sir, Professor Ranbir Singh, to deliver welcome address.
I extend very warm welcome to Honorable Mr. Justice Ravindra Bhatt, Judge Delhi High Court, and the Professor B.T. Kaul, Chairman Delhi Judicial Academy, Dr. Mrs. Santosh Chawla, Dr. P.K. Jain, Dr. Majumdar, Mr. Viplav Bakshi. I also welcome the entire staff of NLU Delhi, including Dr. Priya Rai, who has been responsible for organizing this conference. She has done a wonderful job. Give her a welcome. Also, actually, a very warm welcome to all the officers of the Society of Library Professionals, Special Library Association Asian Chapter, United Nations Information Center for India and Bhutan. I welcome all the chair, co-chair, panelists, library officials, and participants. I'm sure the two-day deliberations have been a very fruitful experience for all of us. As the figure I have, sir, we had total 62 papers these 2 days, and there are participants from 14 states, and the total invitees were about 185. To be correct to this. So, in all, the conference was a huge success, and we have come out with a publication which will be presented to you at the end of the conference. The New Age Libraries is a hybrid form of a library that deviates from the traditional bookkeeping library of the past. Digital libraries has to maintain actual and statutory balance in copyright laws, which we discussed these 2 days, in preserving and sharing information under the provisions of libraries. In fact, the mandate of the law libraries of tomorrow is going to be, if I put in brief, if you look at legal education itself, we have more than 1100 colleges in the country. We have 250 law faculties, we have 20 law schools now. The mandate of the library would be, especially in the law schools which have the so-called good libraries, would be to cater to the needs of these libraries outside the islands of excellence which we call the national schools. So there's a need to link all these colleges, law colleges, and I will go beyond that, link all the high courts and the Supreme Court and the institutions relating to law with the digital library resource. That would really help everybody who is interested in the legal profession in doing research. That is going to be the future demand of the electronic libraries, in fact. and that would create a good balance between copyright laws and intellectual property policy. Every university would have to have a very strong IPR policy, which is very important these days. The libraries have to be depositories in real sense, having access and making use of creative works and the dynamic use of internet facilities. NLU have raised a point as we amending the intellectual property law with the aim to consider favorable changes in society caused by the information technology. I welcome the Society for Library Professionals, Special Library Association and United Nations Research Center for India and Bhutan for joining us to organize this wonderful conference. I hope this conference propounds platform to inform professionals to learn some new resource of emerging and persuasive information on IPR. I think your 2 days stay must have been wonderful at the campus, and I always say if there have been faults, the responsibility lies absolutely on me, and if we have done a good job, the credit goes to Priya and our team. Thank you very much for coming and for your time.
Thank you, sir. Now I request Honorable Mr. Justice S. Ravindra Bhatt, Judge Delhi High Court, to deliver keynote address.
Professor Ranveer Singh, Vice Chancellor, Dr. Santosh Chawla, Mr. Akash, Dr. Priya Rai, participants, ladies and gentlemen, gives me immense pleasure to be here amongst you in this concluding session where I address you in this valedictory session. First, I am delighted to again meet Dr. Chawla. We were just exchanging notes, and I was telling her I held Justice Chawla in the highest of esteem, and I continue to do so. He is a continuing source of inspiration to our generation of judges and lawyers, and also all those who care to read and try and discern his values. It is said that knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. So, this was said by James Madison 220 years ago, and that holds good even now. The challenges that society faced and the challenges that this society faces may be different, but many concerns are common. I was quite surprised, and the depth of your deliberations took me by surprise. I noticed that you held not less than 8 technical sessions, and each one of them spanned issues concerning digital rights management and its interface with intellectual property laws. New age libraries, and typically we are talking of digital libraries, are not just the old style libraries that we are familiar with. We have digital rights management processes which copyright owners typically deploy to lock digital resources, which have to be which are a matter of concern when we are talking of knowledge dissemination. And I understand that the endeavor, and I must confess my unfamiliarity with the subject, is that the interface here appears to be the same old concern. The first issue which arose in copyright was, what is the extent of copyright? The first case, the first big case, is what is known as Donaldson versus Beckett. The first statute on copyright, the Statute of Anne, said that it should be only for 14 years, plus another term of 14 years during the lifetime of the author. Once that was up, the copyright owners tried to get back, saying there is a common law right. And then they started suing people who published it. or even published parts of copyrighted or expired copyrighted works. So they were ingenious because they started saying that notwithstanding the fact that a law had given me limited protection, I still have a subsisting right outside of that law in what is known as common law. So the first challenge was answered as far back as in 1774 by the then 30 judges of the House of Lords. They said that this will amount to tyranny and usurpation of the right to disseminate knowledge. Well, those issues don't seem to die down, they keep cropping up. In Eldred versus Ashcroft, this is what about 227 years later, in 2003, the American Supreme Court had to decide on the validity of the extension of copyright itself. Now it is, I think, 70 years after the lifetime of the author. Those days it was 60, they wanted to extend it by another 10 years. So the author, the people who wanted access, they said that this is unconstitutional, this is wrong, because you are enclosing this. Well, the Supreme Court upheld it, US Supreme Court upheld the extension, but there are two very telling dissents. One of the judges said, how will extension help today's Noah Webster create works 50 years after his death? Because copyright is supposed to protect, and it does, protect expression of creative ideas. If it is, then 60 years is enough. But if you want to extend it by 10 more years, how is it going to promote innovation? If you are going to protect somebody's grandchildren's right to royalty. Similarly, Justice Stevens said, frustrating the legitimate members of the public who want to make use of it in a free market is wrong. Now, one of the latest conflicts has been, what is fair use? Now, I'm sure all of you must have been taken through this in many sessions, so I won't bore you with this detail. It's just that you are now familiar with the concept. Fair use is that which reduces the intolerability of a monopoly in the sphere of copyright, and it restores some semblance of balance, some semblance of equity, in the sense that for researchers, knowledge is the lifeblood. It is the breath of innovation. It's the breath of thought. If you are unable to access works, whether they are digital or on print, then your capacity to think and travel beyond what exists is severely curtailed. Once Bernard Shaw had said, in this context, Bernard Shaw had said that Shakespeare is taller than me, but I stand in the shoulders of Shakespeare. What he meant then was that knowledge is incremental. I gain because I read, and then I am a product of my generation. Therefore, I am able to express what I feel, whatever I have assimilated, and innovate with those thoughts behind it. Now, is that possible if you don't have a concept like fair use? Everybody would be prevented from accessing works genuinely as a scholar, as a researcher, and he would have to buy, or he would have to part with the royalties and whatever is demanded in order to have access. Recently, this issue had come up. I am not very sure whether you have been told about this. There is a case known as the Hathi Trust Digital Library, case which was taken up in the US. Several research universities, including Michigan, Berkeley, Cornell, and University of Indiana, agreed to allow Google to electronically scan the books in their collections. In October 2008, 13 universities announced plans to create a repository for digital copies and founded an organization called the Hathi Trust. It permits use of 3 uses of copyrighted works in the HDL repository. First, the trust allows the general public to search for a particular term across all digital copies in the repository. Unless the copyright holder authorizes broader use, the search results show only the page numbers on which the search term is found within the work and the number of times the terms appears in each page. You must be doubtless familiar with this because you can come across this in the internet when you even enter a simple Google search. The HTL does not display to the user any text from the underlying copyrighted work, even in snippet form. Second, the HTL allows member libraries to provide patrons with certified print disabilities access to full text copyright works. Third, by preserving the copyrighted book in digital form, the HTL permits members to create a replacement copy of the work if the member already owned an original copy. The member's original copy is lost, destroyed, or stolen, and a replacement copy is unobtainable at a fair price elsewhere. The University of Michigan also developed a project known as the Orphan Works Project, which was to collect out-of-print works which had still copyright subsisting in it. These were identified as orphan works and made accessible in digital format. A number of authors' organizations challenged these activities. The district court decided the case in favor of the libraries. It held that HTL's use of copyright material amounted to fair use. In this assessment, the district court gave considerable weight to what it found to be transformative nature of the three uses and said that what it described as HTL's invaluable contribution to the advancement of knowledge. The Court of Appeals upheld the district court's judgment. It rejected the proposition that transformativeness was in part determined by contribution to advancement, but at the same time, in the fair use analysis, it said that the creation of a full text search database is nonetheless quintessentially transformative. Then it also said that the fair use analysis is justified by the fact that authors admitted that they were unable to identify any specific quantifiable past harm or any documents relating to any such past harm. So this is where it stands in America, which means that today, if you have a digital rights management system and you are digitally having a repository, it is better that you create a mechanism whereby limited access is provided and you have a record of it, and not the entire access. And then that these, I suppose these things can be found out by a pilot project, and this would, I'm sure, create a huge database, what would one term as a knowledge grid, which would be immensely useful for scholars, teachers, and the policymakers, courts, etc., because it has the potential to completely transform the way we research. And currently we are looking at resources in a very fragmented manner. We have to go to multiple searches, etc. We have to go to multiple places. Sometimes things are available, sometimes they are not. The advantage in having this is that you are pooling everything, and at one go, the person anyone who wants to use it has the benefit of it. Now, I'm sure that this conference and this meeting, you must have arrived at your own resolutions, discussed your common problems. I'm hardly a technical man either in terms of what is digital rights management or in terms of your own library science, which is itself a specialized field. But I know only one thing as a user, that we typically as a lawyer or a law student, the great amount of time which one took in physically taking out digests and looking up the law and then trying to collate it, looking up the different quotations from judgments, textbooks, was very time consuming. With the advent of the internet, with the advent of computer usage and availability of legal database, things have got simplified to such an extent that sometimes I feel that I'm missing out because I don't pick up volumes of reports or hard textbooks for long periods of time. But nonetheless, the advantage is that if an idea strikes you, you have the facility of hitting the key, just keying in a few words and then trying to search this in a defined database, or even in a wider Google search or any of those search engines which are very powerful. So the law in this, and I just want to conclude, these challenges will always be there, and with technology always outpaces the law. Technology outpaces policy. So the endeavor of the law and the policy maker is always to ensure that balance which ensures access, equitable availability of resources to the optimal best to all, and at the same time protect what ought to be protected, because without that protection, innovation and protection and rewarding of skills, innovation itself becomes useless. Thank you.
Thank you, sir, for providing us thoughtful insights about copyright and digital right management. Now I request my colleague, Mr. Akash, to present conference briefing.
Honorable Mr. Justice S. Ravindran sir, Professor Dr. Ranveer Singh sir, Dr. Santosh Chavla ma'am, Dr. P.K. Jain, President Special Library Association, Dr. Akash Sharma sir, Librarian UNIC, and distinguished guests and delegates. It is my privilege and pleasure to put forward the briefing of this conference. The journey of this conference started when, in September, when Dr. Akash Sharma sir, Dr. Bhatt sir, and Dr. Priya Raiman met our Vice Chancellor. And as our Vice Chancellor sir always support us, he just said yes for this conference. And we started this conference on the theme transforming dimensions of IPR challenges for the new age libraries. And immediately after, in the month of September, we launched a website for this conference and called for the paper. During the paper, we received around 62 papers, and finally the day came on 23rd January. The conference was inaugurated by the welcome address of Professor Ranveer Singh sir, and with the keynote address of Honorable Justice A.P. Shah sir, Chairman Law Commission of India, and also addressed by the Mr. Kiran Meher Kher, who is the Director with UN. Conference witnessed much brainstorm and many informative sessions involving a large number of eminent people, judges, advocates, library luminaries, scholars, computer scientists, activists, and practitioners. And I'm very happy to inform you that all over the India, we had, as sir has also already mentioned, we had participants from 14 states. It's a big thing. The conference had 9 technical sessions on 4 sub-themes. We discussed on IPR issues, copyright and related issues and new age libraries, and internet challenges and IPR issues, and policy and managerial issues in libraries. During conference and these 9 sessions, 36 speakers, chairs and co-chairs were present, and they just gave their intellectual output during the conference. 50 contributing papers were present on various themes related to IPRs and copyrights. More than, as sir has already explained, 185 or around 200 participants were there during the conference. During the conference, we considered and we just considered the recommendations, recognized recommendations. I am just explaining. The conference recognized that worldwide open access of research outputs improves the quality of research in 2 ways, that is prevention from plagiarism and more citation of research output. If our research is in open access, so it's very easy to catch the plagiarism, and if it's coming in open access, so it's our responsibility that we will maintain the standard of this research, because people are saying. The second thing, the conference revealed that we must bring awareness among the librarians and researchers pertaining to the copyright provisions and principles. The librarians must aware about the copyright principles, how they should respect and how they can prevent the copyrighted material and suggest the readers. The conference also recognized that the laws give the copyright protection on the owner of the copyright, but in order to wider dissemination of the information, it is required to reduce the term of protection of copyright holders, as Honorable Sir said, that after the death of the owner, 70 years, it means the fruit is, basically the benefit is just transferring towards his ancestors. The conference recognized that the laws gives the librarians must respect copyright laws and make aware the users about the importance and values of the copyright laws. And today it is the day when it is coming to a promising end with these recommendations, and I also request you, after returning to your organizations, please send the recommendations and the understanding what you understand here during the conference. Thank you very much.
It's my pleasure to invite Dr. Anu Surendranath, Assistant Professor of Law, to present a brief about the death penalty project and launch of website. Anu, sir.
Thank you, Priya. And also I'd like to thank the Vice Chancellor for giving the opportunity to launch the website here. And I think it's an appropriate occasion given the discussion on the problems of disaggregated information and the challenges of bringing information together. And I think the administration of the death penalty in this country is one such issue where we faced immense challenges in putting this. Just a little background, this is the result of the work we've been doing for over 18 months now with the Death Penalty Research Project that is being carried out in collaboration with the National Legal Services Authority. It was a collaboration that was authorized when Justice Satasivan was the chairperson. What we've been doing is we've interviewed all of India's death row prisoners across all jails in this country. We've tracked down each of their families. We've had a wonderful team of student researchers, 90 of them who've passed through at various stages during these 18 months, and a wonderful team of 12 researchers who are here, who stayed with us for most part of these 18 months and continue to work towards analyzing all the data that we have collected. The aim of the project is to develop a socio-economic profile of India's death row prisoners, and also map their interaction with the criminal justice system in what happened in their cases at the trial, at the investigation stage, the trial, sentencing, appellate procedures, mercy procedures, and all of that. We've finished all the interviews. We are currently in the process of analyzing the data to prepare the report. Simultaneously, we've been doing work to develop this website so that we can put out in the public domain some very crucial information that we've been collecting. As it says, as you can see, the website aims to be the definitive source of information on the death penalty in India. I think we've made a decent beginning, but there's a long way to go, and I would urge all of you to use the site and let us know what else can be done in terms of improving the information that we've put out, or what information we can collect. And as I said, the challenges have been huge. Like beginning with the basic thing about how many death row prisoners are there in India. The number put out by the National Crime Records Bureau is inaccurate. The only way to actually know how many death row prisoners there are is to actually verify it at the last mile. That means going to each jail and getting the number out of there. Not even the prison departments in each of the states have the consolidated information that they have is not accurate, right? So in terms of, if you can just, Sam, if you just scroll down, what we have on the home page is in the map, you can You can go to each state and you can click on any state and it will give you the number of death row prisoners in various categories as to how many cases from that state are pending before the Supreme Court, how many are confirmed by the High Court, how many are pending before the governor, and all of that. For each state, you can get that information. Also on the project status tab, if you go, that basically shows you the states that we have covered, the states where our work, some of our work still remains to be done due to lack of permission from the state governments, and where there are no prisoners sentenced to death during. On the right hand side to your screen, you can see the list of prisoners whose mercy petitions have been denied and are currently on death row. And it gives you various details. If you click on each of their names, it gives you various details about which jail they are in, how long they have been incarcerated for, when the Supreme Court gave the decision, when the trial court gave the decisions. You'll have a whole host of details for each of these prisoners. If you just go back up. Now in the death penalty information tab, if you go to prisoner information, you can see each state wise. You can see, like if you click on Assam, it will give you the prisoner. As you can see, we have not put out the prisoner name. That is because it's to preserve the privacy of the prisoner. We have only coded their names, but it will give you date of incident, sessions trial judgments, and the case details as to the sentencing judge. Again, those are categorized in terms of at which stage the death penalty case is currently at, right? And also gives you a state-wise number, and that is current death penalty information, and we track it constantly and we update it, right? Now, if you go to death penalty in India, on the top of that page is a timeline of death penalty since independence. The timeline lets you expand or contract as you want. You can see it year-wise, you can see it month-wise. We've used that, and it has a whole host of political information, popular culture, legal developments on the death penalty. And slightly lower down, you have the sections punishable by death. How many provisions in India have the death penalty? You'll see a total number of 61 provisions. How many are non-homicide? How many are non-IPC? All of that's there. If you go back up, now if you go to the judiciary tab, that's something I'm personally quite fascinated by. And it's for each judge. We have a list of 25 judges whose we've tracked their. If you look at Justice Chandrachud, we've tracked each of their performance on death penalty cases. We try to give as indicative a list as possible. It gives you how many death penalty cases they participated in while in the Supreme Court. It tells you their role. Was they part of the quorum? Did they author an opinion? And the color code tells you what they did. Did they uphold the death sentence in that case? Did they commute it? Did they enhance the sentence? So each color code stands for different outcomes in the case. So you can contrast a Chandrachud with, let's say, Justice Pasayat, who you will see, of course, having confirmed quite a few death sentences. And as you can see, the role is that of author as well. So quite active on the death penalty. Now, if you go back, in terms of executions, the first thing we provide is one of the tasks, and it's something that's fascinating about the death penalty that we found. Nobody has a list of who are the prisoners that India has executed since independence. No jail has record. The Ministry of Home Affairs does not have records. The National Archives will not allow us to access MHA records. So what we did, the Law Commission in its 1967 report mentioned that from independence right up to 1967, about 1,400 individuals were executed. But nobody has names, cases, or any of that. So we identified the jails where there are gallows across the country. We wrote out to all those jails. We got responses, and some jails didn't give us responses. Some jails wrote to us saying, we are sorry, we'd like to have given it to you, but they have been eaten by moths and all other kinds of insects, so they don't have the records. So anyway, we have put together the responses that we received, and it shows the sorry state of affairs that a cumulative number, and as I said, the idea is to remove this anonymity of numbers and actually put names to those figures. And you can see for each state, we have names, their date of execution. For some states, we were able to send us the age at the time of execution, many were not. But unfortunately, this cumulative number comes up only to 750. While in 1967 itself, the Law Commission had recorded that over 1,400 people were executed. But that's the sorry state of affairs as far as record keeping is concerned by government agencies. So anyway, you can access this record to see who were the... Another thing we have are prominent executions. We have a list of about 10 prominent executions. So one of them is Satwant and Kehar Singh for assassination of Indira Gandhi. How we did this section was we sent out our researchers to the Nehru Memorial Library. In the Nehru Memorial Library, we accessed backdated newspapers. We archived the newspaper reports in 10 of these prominent executions like Auto Shankar, Ravji and all these cases. And we have scanned those newspaper reports. You can access those newspaper reports for each of these cases. And this is for Satwant and Kehar Singh, one of the newspaper reports that we have. Moving back to the, and one more thing, another section we have is there are opinions. We have interviews with prominent people, criminal law lawyers. We thought we must be fair, so we have put out those oppose the anti-death penalty, and also, as you can see at the end, we have Ujjwal Nikam. I would urge all of you to see what Mr. Nikam has to say about the death penalty, and also then listen to Mr. Yug Mohit Chaudhary to listen to a strong counter to that. In terms of the research project, we have project resources here. Here you can read the narratives of the student researchers we sent out, what their experience was. And I think there's been a tremendous learning curve, and I think that's personally, I think as a teacher in this university, I think that's been a huge contribution that we've been able to make to their lives. To send them out to these far-flung places, meet families of these prisoners, meet the prisoners themselves, and challenge many of their notions about the criminal justice system and the legal system in this country. And some of these are very moving narratives of what they felt when they conducted these interviews. That sense of helplessness, that sense of frustration, the sense of angst of not being able to do anything much about this situation. Another thing that you can see here in the research project is the death penalty litigation clinic. Arising out of this work that we've been carrying out for the last 18 months, we have now established the death penalty litigation clinic, where we represent and we handle litigation for death row prisoners. We, due to wonderful support we received from the Vice Chancellor, we established it in August 2014, and we currently handle the legal representation for over 30 death row prisoners across the country, and we have three full-time lawyers helping us with this. So, as I said, please do take time to explore the website. Our aim, as I said, is to become the definitive source and put everything that's available, and also gather, and please tell us what else you would like to see on the website. It takes a lot of time and effort, but that's certainly worth it, I think, for an issue like this. And I think it's one of the most fundamental constitutional challenges facing us today. So please do not hesitate to send us critical feedback. Very often that's more helpful than words of praise. So please do explore it and do write to us. You can find the contact details on the website. And really thank you for this opportunity for introducing this.
Thank you, Dr. Anu. It's really very wonderful. Now I request my colleague to bring the certificate for distribution of best paper. I request Professor Ranveer Singh, Vice Chancellor, sir, to present the best paper to Ms. Kankana, Assistant Librarian, National Law University, Assam. Wadhwa from Assistant Professor from Amity University. Thank you, sir. Now it's my turn for concluding and vote of thanks. Honorable Mr. Justice S. Ravindra Bhatt, Judge, Delhi High Court, Professor Ranbir Singh, Vice Chancellor, National University Delhi, Dr. Santosh Chavla, Mr. Akash, distinguished guests and delegates, my fellow colleagues and dear students. On behalf of organizing committee, it's my privilege and profound to vote of thanks and concluding remarks for the conference. I would like to express our deep gratitude towards Honorable Justice S. Ravindra Bhatt for his august presence this evening and delivering the valedictory address at the concluding session of the summit. We are deeply honored to have you here, sir. Sir, during the conference, we had deliberated upon various issues like applications and significance of IPR to new age libraries, utilizing latest technologies under copyright review, issue of copyright, fair use and libraries, internet challenges, exploration of copyright laws in open access epoch, confronting plagiarism issues, legal obligations of social networking sites, cloud computing, management policies and security issues in digitized environment. On behalf of organizing committee, I would like to express our sincere thanks and gratitude to Honorable Vice Chancellor Professor Ranbir Singh sir for all encouragement and unstaining support in all our endeavors and make this conference success. I would like to thank Professor B.T. Kaul, Chairman, Delhi Judicial Academy, for his kind presence. Thank you, sir. We are really very grateful to Dr. Santosh Chavla, Madam, for supporting her invaluable time and presence. Thank you, ma'am. I express my gratitude towards all the guests and delegates, senior librarians and information professionals on this occasion for their presence and hope this conference will provide it with closer look with IPR issues. I thank all the members of various committee, advisory committee, program committee, organized committee. I am thankful to Dr. P.K. Jain, Librarian, Institute of Economic Growth, President, SLA Chapter, Dr. R.K. Sharma, Librarian, UNIC. A special thanks to various levels in the department at NLU colleagues, Mr. Akash, Dr. Samar, Ms. Seema, Mr. Menon, Ms. Reena, Ms. Sangeeta, Mr. Amit Manipal, and all the members of the family for their extensive support. I am thankful to Mr. Rawat, Mr. S.D. Sharma, Taraji, Mr. Lathar, and all my fellow colleagues. We gratefully acknowledge the support of our sponsors and partners. ICSSR, DRDO, CSIR, our corporate partners and sponsors, Mohanlal House, Westlaw, LexisNexis, Walter Kluwer, Taylor & Francis, Rapid Radio, Oxford University Press, Cambridge University Press, Wickman, Bilani Infotech. I convey my thanks to all. Now I invite you to join us for high tea. Thank you.